We actually have one of the best asset forfeiture regimes in the country. In North Carolina, most of the time, there are a few exceptions, but most of the time, if the police think that some property has been used for a crime or was acquired through criminal activity, they can seize the property, which is right and proper, but they have to show that they have to bring a charge against the owner. The owner has to be charged with a crime, and they have to prove by at least a preponderance of evidence standard that that property was in fact used to commit the crime or was acquired through a crime. So that's the way it's done under North Carolina law. That's the way it ought to be done. The only reason North Carolinians have really got to worry about this other process, which is civil asset forfeiture as opposed to criminal forfeiture, is because federal laws are being used in North Carolina to preempt state law. And that's the problem that we're addressing in this paper.
So you are saying that there are local law enforcement agencies in North Carolina who are somehow working with the federal government on this civil asset forfeiture? And if that's the case, what do they get out of it?
Well, they get a lot of the proceeds. The way this works, the federal government revived civil asset forfeiture as a sort of a novel tool in the war against drugs back in the 70s. It was codified by federal law in the 1980s, and the feds started using it in a big way. Gradually, most states put in place their own civil asset forfeitures, but to our credit, North Carolina never did that. Our legislature, in its wisdom, could see that this was a violation of due process and a violation of North Carolinians' property rights, and they didn't go along. However, the feds also started encouraging state and local law enforcement agencies to take advantage of federal laws. And the way it works is this: if that state policeman pulls over a driver and takes their cash, or if they take the vehicle, or if they take a house, they can go before a federal magistrate and have that magistrate process the seizure under federal civil asset forfeiture laws. And then through a program that's called Equitable sharing, 80% typically of the proceeds go back to the law enforcement agency that made the seizure. And if I might just digress for a moment, part of what makes this so egregious in North Carolina is under our state constitution, all fines and forfeitures are meant to be used specifically for public education in this state. That's a very good feature of our constitution, and it keeps the law enforcement honest because they have nothing to gain by bending the rules and taking people's property without convicting them of a crime. The feds don't do that, and as a result, this is a way state and local law enforcement can get the proceeds rather than have them diverted to public education as they ought to be.